Thank you, ladies and gentlemen, for coming back. We're back in session.
You
Madam
have an
Clerk.
announcement?
Yes, I do have an announcement. Ladies and gentlemen, we're going to be having a little housekeeping and some rule changing here. From effective immediately, even during breaks, this area known as the well, which is the diocese, and also where that front border is, where the podium is, it's kind of going to be a restricted area. Only staff will be allowed in that during breaks. If you want to speak to any supervisor, the supervisor will come down and speak to you in the audience. There's several reasons for that. Number one is we have some very sensitive cords here, and we've had some technical difficulties, and it's kind of a problem that we're trying to correct. Also, there's also information that is confidential, so in lieu of that, we need to keep an area safe and make sure it's secure as far as information. So once again, even during breaks, no member of the gallery or the public will be allowed beyond that point except staff where they're seated now.
Does
Okay?
that also include before and after the meetings?
That is before and after the meeting.
Thank you.
All right. Supervisors, you're aware of this? I know you weren't aware of it until just now. Okay. I believe that's it, Madam Clerk.
Item 27 is from the Planning Department to conduct a public hearing and adopt a resolution upholding the Planning Commission's denial of 2016-1123 appeal of the Planning Director's denial of commercial cannabis registration 2016-106 filed by Peter Couloris for Rafael Calderon and Mountain Farms Incorporated at 833 State Route 49, San Andreas, T4N R12E, Section 20, APN 044-006-028.
Okay.
Good afternoon, Peter Maurer for the Planning Department. With me is Ethan Turner from County Council.
Okay, Mr. Maurer, can I interrupt you? Is there any representation from the appellant? Could
Good
you
afternoon,
identify
all.
yourself? I'm
My
sorry.
name's Adrian Lambie with the law firm Archer Norris. I'm here on behalf of the appellant.
I'll be recusing myself on this hearing and stuff. So I won't be on this. I recused myself earlier at the closed session too.
And is this using for personal reasons?
Yes.
Okay. Is the appellant here?
My client's here.
I'm also Peter Couloris, appearing for and with the appellant, with the president.
And the appellant?
Ralph Calderon with Mountain Farms.
Okay. Gentlemen, we're going to be having a hearing, so we'll open the hearing now.
Thank you. So as stated by the clerk, this is an appeal of the Planning Commission's action to deny the appeal filed on the Planning Director's action, which denied cannabis cultivation registration number 2016-106. As stated, it's located at the old airport, 833 State Route 49, south of San Andreas. The zoning is M1 light industrial. The arrow points to the structure in which the cultivation activity was located. Again, this is part of the old airport property. This is the site plan that was submitted with the application. It shows the building and the parcel in which it is located. And this is the site plan that was submitted. As you can see, it's broken into three different sections. There's units A, B, and C. We'll get into the details of these units later as we discuss the issues associated with the appeal. Just as a background, a little chronology, application was filed by Mr. Calderon for Mountain Farms on June 8, 2016 for 10,000 square feet of indoor cultivation. It was denied by the Planning Director on November 1st, 2016 after an inspection was made by different agencies within the county on October 27th. That action was appealed by Matt Clark, at the time representing the appellant or the applicant, on November 14th, and a hearing was heard by the Planning Commission on December 22nd. The Planning Commission denied the appeal, upholding the planning director's denial of the cannabis registration, and that action was appealed by Mr. Colares on behalf of Mr. Calderon and Mountain Farms on January 5th. We've had two previous requests for continuance, which is why it's taken so long to get to this point. We agreed to that continuance, and we're now at the hearing for today. The reasons the planning department, the planning director denied the application was that there was inadequate evidence of cultivation on the site or preparation for 10,000 square feet of indoor cultivation. We also identified a number of code violations and violations of law, and felt that there was false and misleading information that was presented in the application, and that the lease that was provided did not provide lawful possession of the full premises prior to May 10th, 2016. The commission upheld that action, finding that there was inadequate evidence of cultivation prior to May 10th, that there was no valid lease showing lawful possession of the property prior to May 10th, and because of the violations of county code and other laws. To go into a little more detail on that, 1795-165N3 requires evidence satisfactory to the planning director of demonstrable steps toward developing cultivation site by providing photos of earth moving or grading, or photos of cultivation. And both or either must be commensurate with the area proposed to be cultivated. The actual code of the ordinance is in the staff report. I'm sort of summarizing here. We had a number of photos that were submitted. They were dated April 27th through May 6th of 2016. And just sort of go through these so you have the full ability to see what those are. I'm going to turn the lights down for a minute so we can see better. So these were the photos that were submitted as a part of the application. This shows some plastic sheeting being hung inside the building, some remodeling being done within the structure, rolls of carpet being removed, more remodeling being done, and several pictures outside the building. The last photo was submitted at the Planning Commission hearing, shows more rolls of carpeting being moved. This was dated August 12, 2015. This was the extent of the photographic evidence that was provided to the county with the application and provided to the Planning Commission at their hearing. So the commission found, based on this finding, that there was no grading or earth moving, or grading and earth moving didn't apply to indoor cultivation, because obviously you don't need a grade to do that unless you're constructing a new building. And the photo evidence showed that there was no cultivation commensurate with 10,000 square feet. And the appellant actually admitted in the hearing that he was not cultivating at that time, so there could not have been photos of cultivation. So the commission found, based on that they did not meet the requirements of 165N3 to satisfy the code requirements. The appeal claimed that the statute is discriminatory against indoor cultivators. This was not raised at the Planning Commission hearing, and therefore is really inadmissible at this hearing. But we just wanted to bring it up because it was in the letter. The code on appeal states that no new issues may be raised that were not raised at the previous hearing. And so this is really immaterial. But the idea that there was some type of protected class at indoor cultivators or somehow should be treated exactly the same as outdoor cultivators is not really relevant. Indoor and outdoor cultivation is different. They have different impacts on the environment, and it's rational to treat them differently. The code is very clear: photos of grading or earth moving or photos of cultivation. And so that's what the Planning Commission based their finding on. The appeal also raised the issue that they had made a substantial effort to prepare the site for cultivation. It was the intent of the ordinance when the board adopted on May 10th to freeze cultivation activity, what was there on May 10th. And while there was some preparation for cultivation occurring on the site, it was not commensurate with 10,000 square feet. They only had access to 8,000 square feet at the time. The site was still being used by other tenants in units A and B, and clearly the photos did not show 10,000 square feet worth of preparation for cultivation. The appellant stated it was his intent to expand at a later date, which is clearly in opposition to what the board's intent was, to freeze cultivation activity on May 10th. The second issue was regarding the lease, and 165N2 requires a recorded deed or signed and dated lease demonstrating lawful possession of parcel to be registered prior to May 10, 2016. There was a lease. It was signed on May 1st. It provided immediate possession only of Unit C, which consists of 8,000 square feet. Tenants were still occupying at least until July of Units A and B. In fact, there's a gymnastics studio that was there. People locally probably remember it. And so it's not possible that the operator of the cannabis cultivation site could have access to those other two units and able to cultivate and prepare for cultivation 10,000 square feet. The Planning Commission found that there was no valid lease for the full area that was being used. Again, Unit C could only accommodate the 8,000 square feet. The lease agreement states that no exclusive possession of Units A and B until August 1st of 2016. And again, other tenants were continued to operate, and that should have been 2016. But then there were cultivation activities going on after that date. So obviously there was expansion of cultivation into an area that was not previously authorized under the urgency ordinance. In the appeal letter, they state that there was a lease that predated May 10th that provided access to all three units. But again, the lease only provided exclusive access to Unit C. The lease was graduated to allow expansion to the Units A and B after August 1st. This is contradictory to the intent of the ordinance, and A and B were occupied by other tenants. So the fact that they had a lease did not satisfy the requirement that the lease provided access to and possession of the full area to be used for cultivation. Again, as they stated, the plan was to build out the premises over time, and they argued that the code anticipated that there would be future expansion. Under 165A2, it talks about canopy area that is or will be on the cultivation site. It is true that the ordinance allows for future cultivation where someone had prepared the site, particularly outdoor cultivation where they graded. If it had been previously graded, then they could continue pursuing the cultivation operation. But if they had not prepared the site and didn't have access to the site, that did not give carte blanche okay to continue to expand the operation. And this is what happened here. So the site was not prepared, and so the fact that we did allow for cultivation to occur after May 10th, but only if they prepared the site, only if they met all the other requirements of the code. And clearly this activity did not. The third finding that the Planning Commission made was that there were violations of county code and other law. Sections 165E, F, and H require cultivation activities be conducted to ensure the health and safety of employees and in compliance with federal, state, and local laws. Subsection 170A provides for invalidation of registration for failure to comply with Chapter 1795, violations of other laws, or registration containing false or misleading information. Planning Commission found that there were a number of code violations that were identified on October 27th. These were deemed to be dangerous, and the structure was unfit for human occupancy. It is, well, let me get into that later. Further violations were identified as undocumented workers working on the site and were sleeping or camping in the structure. There's a number of unpermitted electrical work, generators, and other code violations. The appeals claimed that there were other instances where the county had allowed people to repair and correct violations. This is true. We have allowed, in some instances, code compliance teams say, well, this is not in compliance. You have a certain amount of time to fix that. In some cases, the citations are minor in nature and can be repaired, can be corrected. In other instances, they're not. They are hazardous. This was deemed to be hazardous enough that it required immediate closure of the building. It was sealed off to prevent any access. And so there is no requirement that we provide a citation before a closure order is issued. There were hazardous conditions. There were undocumented workers in subleased space. These were violations that were occurring, and there was no need to provide some opportunity for the appellant to correct those. So in summary, the Planning Commission denied the appeal on December 22nd based on the findings that there was no cultivation or grading prior to May 10th. There was no lease providing possession of the site necessary to cultivate 10,000 square feet prior to May 10th, and there were violations of county codes and other laws. Staff therefore recommends that you deny the appeal, upholding the Planning Commission's decision to deny the appeal of the Planning Director denial of 2016-106. Do you have any questions?
Any questions by the board?
I have a couple of follow-up points. The first being that, as Peter alluded to, Section 17.98.070B of our county code precludes the appellant from bringing forth legal issues and arguments that were not brought forth at the Planning Commission. In the appeal letter, there's 3 such issues. The first is on page 3, which is 432 of your board packet. Mr. Caloris argues that the ordinance is discriminatory as applied and unconstitutional. That legal theory was not brought up at the Planning Commission and should not be heard here today. The second is on page 7 of the appeal letter, which is 436 of your packet, that similarly situated applicants were allowed to reduce cultivation area, and that argument should not be brought up here today because it was not raised at the Planning Commission level. The third is on page 8, 437 of your packet, the argument that other similarly situated applicants were allowed to make post-inspection corrections of their sites. That too was not brought up at the Planning Commission. I also wanted to hammer in a couple of points that Peter made. For those of you who attend these hearings regularly, you'll notice that Commissioner Wooster has a way of distilling the issues and bringing it all together at the end of a hearing. And I'm actually going to read a quote from him that he said at this hearing. There are 2 separate requirements here in the ordinance, 17.95.165N, 2 and 3. 2 requires a signed and dated lease demonstrating the registrant's lawful possession of the parcel to be registered prior to May 10th, 2016, and his or her current lawful possession of that parcel, end quote. The parcel to be registered was the entire building at 20,000 square feet. That's clear on the record, Wooster said. It is also clear to me, he continued, the lease does not grant lawful possession to the entire building prior to May 10th. It just doesn't, on its face. The fact that there were other tenants there reinforces that. So I think the appeal should be denied based on that. With respect to demonstrable steps, the demonstrable steps provision is in section 3. The ordinance says demonstrable steps towards the development of a commercial medical cannabis site on the parcel. And that's where people who want you to have a forward-looking interpretation of the code stop. But Wooster pointed out that it goes on, as demonstrated by the criteria described in either A or B below. It's very clear. It has to be either grading, which is not applicable here, unless you're building a new building or a greenhouse, which it might be, or photographic evidence of cultivation commensurate with the area to be cultivated. Cultivation means plants. It doesn't mean anything else. It doesn't mean rolling up rugs. And the argument that it would have been illegal, well, of course it would have been illegal. all of these were illegal. Outdoor, indoor, all of them. But the urgency ordinance gave them a pass on that. The intent was to stop it where it was. As to the violations, I can't add anything to what the planning director or the sheriff said. And what Wooster was responding to when he made that comment was the fact that it was raised during the hearing that it was illegal to grow cannabis prior to May 10th, so how could they have had cultivation in place prior to May 10th? And Wooster pointed out, yeah, it was illegal, but when they drafted the urgency ordinance, the purpose was to stop it in its tracks, not to expand cultivation. And here, the applicant admitted that there was no cultivation at all prior to May 10th in any of the buildings, and there was none in A or B prior to August 1st. And so he kind of dealt with the first two issues that the Planning Commission dealt with. One, the lease issue, and then the commensurate cultivation activity. And Ted Allard, Commissioner Allard, chimed in afterwards and said there were clearly illegal things going on there that the applicant, in this case, should have known about, and I don't think he can say he didn't know about them with any credibility. And as to the illegal things that Commissioner Allard was talking about, I mentioned during that hearing that I personally went in that building before there were arrests made while environmental health was doing their inspections, code was doing their inspections, and the fire chief was doing his inspections. Peter actually went in too. And right inside Building A, there is a diesel generator between two orchard fans. All this was brought up in the Planning Commission hearing. And workers inside that same building where the generator was running, trimming marijuana. And there was mattresses on the floor. It was obvious they were sleeping there. And if you refer to the fire chief's report, which was presented to the Planning Commission and is on page 685 of your packet, there is substantial fire hazards there, including extension cords laying over combustible material, open fuel canisters, and then the generators running inside. That's all in the fire chief's report that was given to the Planning Commission. And he also noted that the fire exits were blocked by an interior wall, and by one door was bolted. These were all fixed subsequently, but to have those workers in there in those conditions, I mean, is a wanton disregard for their safety. And in the last hearing, the appellant made light of it, saying that they weren't very serious issues, and that, I don't know what to make of that. But he also said that those weren't his workers who were arrested. He didn't have any employees there. He said there was one guy who helped him, that he didn't know why any of the undocumented workers were there, and that he had not sublet the building. It also came up in the hearing that an individual had contacted the sheriff saying that he had sublet the building, or that he was using the building as under Mr. Calderon's authorization. That all came up during the Planning Commission hearing. And we still don't know who those people were, why there were undocumented workers and unwork authorized people in there, and he just didn't answer any of that during the Planning Commission hearing. And that concludes my
Sir?
Thank you to Mr. Turner and to the director for that thorough presentation. Gentlemen will note that there is a couple things conspicuously missing from the chronology that was just presented to you. The first is that on January 20th, my co-counsel, Mr. Coloris, submitted a written request for discovery in connection with the pending appeal to the county, outlining 24 categories of documents that were requested in connection with the appeal. On April 12th, one half of one category of documents was made available for inspection. That half of a category of documents consisted of all the urgency ordinance applications that have been granted to date, some 700 pages of documents which we reviewed immediately. Those documents showed a few things. Firstly, and most importantly, that my client, Mr. Calderon, was held to significantly higher and more rigorous standards than other similarly situated applicants under the urgency ordinance. He was denied by the Planning Commission on 3 bases, all of which the evidence clearly shows other applicants were given a pass on. Based on this newly discovered and newly made available evidence, we promptly submitted a request for reconsideration to the Planning Commission. That request, I see, didn't make its way into the summary of events, but that was submitted to the Planning Commission on April 20th. We are here today to request that the board, pursuant to its authority under Section 17.98.070B of the County Code, remand this matter back to the Planning Commission so that we may present to the Planning Commission the important arguments that we have to make about my client's rights to equal protection under the laws and to a fair hearing under the Civil Code. We therefore request that this hearing be adjourned and that the matter be remanded to planning for further consideration so that we may present this evidence in the administrative stage before having recourse to the courts. My client believes that the administrative stage is the right place to have these important arguments heard, and therefore we respectfully request that the board remand the matter. And the authority again for that request is Section 17.98.070B, which provides in relevant part that, quote, in the event that new information is presented on appeal, the Board of Supervisors shall have discretion to remand the project to the Planning Commission for consideration of new facts or issues. And we therefore submit that request now.
Okay. Submitted. At this time, any presentations by members of the public? You'll be limited to 5 minutes per person. Seeing no takers on that? Anybody wish to speak from the public? Mr. McManus?
Yeah, Bill McManus. I don't know, maybe this is going to get carried on again. What is a recurring theme, it seems like, with all of the grows that we have, all of the appeals, all of the hearings at the Planning Commission and here at the board. In the past, my central purpose was to help people out who had been brutalized by this industry, and that was mainly neighbors and people who lived in close proximity to some of these activities, whether it's at the airport or in District 2, wherever it was happening. Over and over again, as I go through these documents, I see this recurring theme of employees being brutalized. It's not their neighbors. When I hear that generators are running indoors, fire doors are locked, these people are not being taken care of like most employees should with workman's comp insurance, state disability, other protections of the law. I don't know how you deal with it. You know, the criminality just seems to expand out to the point where there's nothing, it's no rule, no laws being followed. And I don't know how you sort that out. And going back and forth between the Planning Commission and the Board of Supervisors, I guess, is one way of handling it. It seems like there ought to be, you know, that the shortest distance between 2 points is a straight line. There ought to be a straight line to resolution on this and get it over with and stop this kind of activity, because it's just going to keep recurring as long as people are given endless opportunities to change the story, to expand the conversation and keep coming back. And so I would hope that the board would just move to dispose of this matter, get it done today, and you've got a lot more business to do than keep going back and forth with this one. But now, instead of just considering the innocent people out in our community, let's start thinking about the workers who are being brutalized and they're not having their rights protected. And I don't think that's anything that's really been brought up before. So maybe we should start considering that too. Thank you.
Any other public comment? You'll have a chance, counsel. Seeing no public comment, we'll have a summation rebuttal by the appellant. You can speak now, sir.
And Supervisor Oliveira, I want to be clear on one procedural thing.
Okay.
In the event the board is disinclined to grant the request that we have just made for a remand, my co-counsel is prepared to address the merits of the appeal today. But procedurally, we would like to ask for that the remand issue be decided first, just to be clear on the nature of my request, if that makes sense.
Okay.
In other words, if the board is disinclined to send this back to the Planning Commission, we would like to argue the merits of the appeal today. However, with respect to what Mr. McManus just said, I would simply respond that that is not before the board today. The breadth of this appeal is confined to the findings that were made by the Planning Commission. And as Mr. Kaloris will argue, those findings, we believe, don't support the conclusion that the Commission reached. But more fundamentally, those findings show a stark disparity in the way that my client's application was scrutinized by the administration here as compared to other similarly situated applicants. And that disparity is of grave concern to my client and to my firm. And we believe it's vital that we have the chance to address that before the Planning Commission in the administrative stage before seeking judicial review. If this wasn't abundantly clear earlier, our position is that the granted applications don't just show isolated cases of similarly situated applicants being given opportunities that my client wasn't afforded. They show a pattern of disparate treatment, numbering in the dozens of applications. And we believe it's very important that that evidence be presented at the administrative stage, and that's the basis for our request.
Thank you, sir. Any staff's rebuttal, summation?
Well, within your prerogative to decide whether or not there's new information that should be sent back to the Planning Commission. I happen to disagree with the attorney for the appellant. I don't believe that we have treated this applicant disparately, but it's certainly within your discretion to do so.
Submitted staff?
I have nothing else to add.
Is there any rebuttal by the public?
Mr. Chair, can we hear from county council? I think you have it.
Most certainly can.
Counsel, my job is to make sure the record is clear. I don't know, it's not clear to me what the new evidence is. Could you please restate what that new evidence is? You made mention of having the opportunity to review some files, but that's a little bit opaque for me. So,
Certainly, Mr. Sirius. And to be clear, I present this as, in essence, an offer of proof, since under the code, we're not technically allowed at this stage to consider new facts and evidence, which is the basis.
right, we're not asking for,
Right.
for the evidence, we're just a better description.
Certainly, I'm happy to provide that. So the documents that were offered to us on April 12th consist, as far as I can tell, of the 45 applications under the urgency ordinance that have been granted to date. Those files include the complete application paperwork, correspondence with the planning director, inspection reports, code violations, if any, and as far as I can tell, again, all the documents that pertain to each application that was granted. Upon review of those documents, those 45 application files, we discovered quickly that the three bases on which my client's application was denied at the planning stage and again by the Planning Commission did not prove to be fatal obstacles to numerous other applicants. For instance, with respect to the argument that my client didn't have a full 10,000 feet of available grow space on May 10th, he only had 8,000, according to the director, and I don't think we dispute that. The idea that that was a basis for denying his application is belied by numerous other applications in which the applicant did not have available to them on May 10th the same square footage that they had applied for. The inspections repeatedly revealed that, for example, the designated grow areas, the fenced areas, were significantly smaller than the square footage applied for. And those applicants, far from being denied, were in fact given the opportunity to amend their applications to conform to the actual square footage of the grow. That's one example. Now, turning, for instance, to the argument that my client hadn't engaged in cultivation, quote, commensurate with the scope of the grow. Obviously, it's already been discussed here that the grading option for satisfying that requirement was deemed not to apply, and Mr. Coloris will address that if necessary. But just looking at the idea of cultivation commensurate with the size of the grow, we've cited in our request for reconsideration to the commission multiple examples of applicants who had not engaged in grading, had not engaged in cultivation commensurate with the size of their application, or anywhere near commensurate with the size of their application, and nonetheless received approval.
Okay, thank you. Ethan, when was the planning commission hearing? What was the date?
December 22nd.
I'm sorry?
December 22nd.
December the 22nd. The request for information was made after the planning commission. So there's a lot of there's cases that go both ways, that they could have had this information before, and that's grounds for not remanding. But there's many cases where people in your position said, well, they just didn't, these are new facts that they didn't think about it, they didn't have counsel, various mitigating circumstances, so we're going to consider this information legitimate that the planning commission needs to hear. So ultimately, it is your discretion, given the facts before you. I just wanted to make the record clear as far as the timeline.
And may I just respond to one point in that regard? Many of the documents that were produced to us by planning on April 12th were generated after December of 2016. They are from the early part of 2017, so it would not have been possible to obtain those documents because they simply didn't exist at the time. And also, I would just submit that this scenario, this very situation that we find ourselves in, is exactly what Section 17.98.070B was designed to address. It empowers the Board of Supervisors to take into account new information that has emerged since the administrative decision and ask, look, will you guys take another look at this? We think it warrants another look before the administrative remedies are exhausted and we move on to the judicial phase.
Okay.
Thank you.
Thank you, sir. Any other member of the public would like to speak on this issue? This is the rebuttal by members of the public. You'll have 5 minutes, ma'am.
I have a big question. Mr. Maurer, was he growing previous to May 10th or not?
You have to address that to the board, ma'am, and then we'll handle that from there.
Number two, wasn't there a gymnasium that makes children in the presence of that area?
This is
According to the
rebuttal.
UO, we're not supposed to have that.
It's a rebuttal. You got to limit it to.
Yeah, it's rebuttal. You have to, okay. Any other member of the public? Does the board have any questions of either the appellant or staff? Supervisor Garamendi?
I've got one. This is for the staff. Is this operation still, it went out of, when it was shut down, they're not continuing to grow there, are they? Is it within 1,000 feet of a sensitive area, area of special concern?
It is, but the urgency ordinance only applied that requirement to outdoor cultivation. It did not require it of indoor cultivation.
Is that intentional or is that just an omission?
I don't know. I'm not sure if it was intentional. I don't recall the discussions we had when drafting it or during the hearing whether or not that was discussed at all. It may have been unintentional, but it is what the code says.
I asked that specifically when I think about things like the warehouses available in Toyon that are across from the middle school. And I'm thinking about this in terms of the baseball fields on the other side of the airport.
Yes.
Any other questions by board members? I have a couple of questions. Mr. Maurer, are we aware of any permits that were required for the modifications made inside the building by the appellant?
After the operation was shut down, he did get permits to fix some of the violations,
Okay. And these were the building code violations?
building code violations, exiting requirements, electrical work, those kinds of things.
Was OSHA notified of the fact that we had workers in a dangerous, unsafe atmosphere? Do we know that?
I don't know. I don't believe so. I don't know either.
Mr. Turner, you have no idea of whether OSHA was forwarded a copy of this report, if you will?
I'm not aware if they were.
I think the fact that it was shut down sort of made that unnecessary. But I don't know the rules about OSHA.
I have a question of the appellant or his counsel. Sir, did your client have any employees at this facility during this time?
I would say, firstly, I'm not sure that's within the scope of the hearing, with all due respect. But secondly, I don't know the answer to that, so I'd have to confer with my client.
Does your appellant know the answer?
I'm sorry?
Ma'am, please. Does your client know the answer if he had employees at this facility during this time period?
I would have to confer with him
I'll give
briefly.
you a
if that's-
moment.
If that's all right, okay.
Yeah.
As evidence to the third finding.
Sir, Mr. Turner.
Sure. So again, you know, our sense is that that may not be germane to the issues that were before the commission. But in the spirit of cooperation, my client says that he was the owner-operator at the time. He had one employee who was at the facility only on a part-time basis.
Okay. Thank you, sir. Mr. Turner, go ahead, please.
And the third finding by the Planning Commission, among the violations listed, was that undocumented workers were employed at the site. And that was based on testimony of the sheriff, who arrested those individuals and processed them at the jail and discovered that they were not work authorized. And the sheriff testified at length during that hearing, and that was evidence that was a basis of the third finding.
Thank you, Mr. Turner. Any further questions from the board?
I think before we rule on the matter in front of us, we probably need to decide whether or not it is within our discretion to accept this new evidence as our first decision, and then we can move forward whether or not we want to continue the hearing.
Well, we can do that, I believe, counsel, on deliberation, or is it just time to do it before we close the hearing?
You should probably make a decision under section 17.9807 whether these new facts are important enough to justify a remand. Because if you justify a remand to the Planning Commission based upon these new facts raised, then there is no need to hear the case on the merits. It would just go back to the Planning
Okay.
Commission.
Then we'll close the hearing and deliberate with the board. Is that what you're suggesting, counsel?
Poll the board.
Yes, you can do that either way.
Yeah.
But you need to make a decision on whether you're going to remand or not, because otherwise you need to hear the case on the merits.
Okay, I'm going to like to close the hearing and then do the deliberation discussion with the board on that issue. Then we'll proceed to the vote if we need to. Okay? Hearing's closed. Thank you very much, ladies and gentlemen. I'll bring it back to the board for discussion and deliberation. Supervisor Tofinelli, you have a comment?
I don't think the evidence is relevant to what the applicant produced at that time. So I'm not willing to remand. I'm willing to hear forward right now. Go forward with hearing and the appeal today.
Supervisor Garamendi?
Concur.
Mike, please.
I concur.
Supervisor Mills?
And I also concur.
And I would make that the 4-0 vote on the unanimous, or concur with that. Bad choice of words was the vote. Having determined that the introduction of any new evidence is not to be considered, am I correct with that, counsel? I would entertain any further discussion or deliberation by the board. Having hearing none, I would entertain a motion
Mr. Chair, I think the applicant has requested that, the decision's made whether to remand or not, but he has not had an opportunity to really present the argument for why he feels the appeal should be overturned on its merits today. So I think it would be appropriate to reopen the hearing to allow the appellant to present his case on the reasons why it should be appealed based on what we have before us today.
Isn't that based on the new evidence we just?
No, he would be
He
then
has other
addressing
evidence.
just what was contained within the.
Counsel, I can reopen the hearing then?
Yeah, you were just ruling on the
I'll
remand
give you that
issue.
opportunity, sir. Hearing's back on.
Okay, thank you, Mr. Chair. And the director's exactly right. My presentation was simply a request that the matter be remanded. That request, I understand, having been denied, I would make one more procedural request for the record. I would request a continuance of this hearing to allow the planning department and county council to respond to the outstanding 23 and a half document requests that are still pending in this matter. I would simply make that request.
Seeing the hearing is still open, is there any questions by the board on that issue, short of deliberation after we close the hearing? Any comment by the public on that particular bit of information?
Can I clarify, what is it what is outstanding?
There was a request made in writing on the 20th of January by Mr. Caloris that itemizes, 25, not 24, categories of documents that he was seeking, and my client continues to seek in connection with this appeal. That document was the genesis, as I understand, for the production of the completed files, or the approved files on April 12th. However, that is only part of one category of the documents that were requested, and we request a continuance of the matter to have those documents produced.
Chair, I believe we've made our ruling that new evidence wasn't going to be considered here, that we would decide based upon the evidence at hand.
That was my understanding.
For that reason, I would like to hear the evidence that the appellant has to help us to make a decision regarding this matter.
Chair, if I may, I have some clarifying comments on what counsel just said. I received a document entitled Request for Informal Discovery on, I believe it was January 20th. I responded in writing to that request, pointing out that during an administrative hearing, you're not entitled to discovery like you are in court, and I recommended several other sources of information to assist in there. I received a subsequent request in writing that had no title to it. It was just an email saying, can I look at the approved applications if we don't have staff time to look at the other ones. Those documents were provided, and that's what I assume he's talking about, being one half of one of the items.
That is my understanding as well. Our office has no records of anything not responded to. We know that Mr. Turner responded to a request for informal discovery, which then led to further communications, which led to the inspection of the files. So we're not aware of any further outstanding request. If the appellants want a continuance because a lot of oxygen was sucked out of the room in requesting this remand, it's not going to happen. That's one thing. But a request based on something pending, I don't think that's appropriate because there's nothing pending as far as our office goes.
I understand. That was my question too. Maybe you could cite a case or something that might help us with this. Are we required to provide discovery in a situation like this?
No. We answered that question in writing. There is no informal discovery in administrative proceedings. Mr. Lambie, if you want a continuance, just ask for a continuance. But it's not going to be based on course document discovery because there's nothing here.
And apologies if I wasn't clear on that. I don't disagree that there's no written discovery in an administrative proceeding. However, under the California Public Records Act, there is a right of any member of the general public, my client included, to inspect these records, and the CPRA would require a response to those requests within 10 days. Now, I understand that the document council received was titled Request for Informal Discovery and did not specifically mention the CPRA. But the law is pretty clear that the CPRA is to be very broadly construed, and any request by a member of the public to inspect official records ought to be construed and responded to as a CPRA request, such that indeed requests that are erroneously titled, for example, FOIA requests, because people don't understand the difference between FOIA and the CPRA, are still to be responded to and processed. So that's the nature of our request before the board. Whether it's termed as a continuance and that's it, or whether it's termed as a continuance pending production of the records, from my client's perspective, is immaterial. We're simply asking for more time to review these materials.
So I guess that we may be disagreeing as to whether we already produced what we produced. I believe Mr. Turner produced what he was asked of him. So that's not on the table as far as our office is concerned. They're just simply, treat it as a simple request for continuance. That's fair. If they want a continuance, you have the discretion to do that.
Okay. Thank you, counsel. Any further comments? I'm going to close the hearing and bring it back for board discussion. Fellow supervisors, regarding the request for continuance, entertain comments. Supervisor Tofinelli?
Yeah, I'm not sure what these documents would have any bearing on this case going forward. I mean, you can't present any new evidence. We decided just previously that we weren't going to accept any new evidence. So whether he had possession of these documents through Public Records Act or disclosure or whatever, it still wasn't presented at the Planning Commission. So what they're trying to glean off of that, I see not relevant to what we have our decision before us, and that's based on an appeal from the Planning Commission's decision based on the evidence presented to them. So I don't favor a delay.
Okay. Supervisor Garamendi?
I think we can move ahead.
Supervisor Mills?
Yes, I believe that we need to rule on the evidence that was presented to the Planning Commission, deal with that as it is, and go from there.
Okay, thank you. I concur. Having said that, hearing is closed. Evidence has been submitted. At this time,
I think appellant has his fallback position is that he wants to put on his case. If you're not going to give him a continuance for any reason, I think he is entitled to put on his case on the merits.
Mr. Sears is exactly right, and for that purpose, I'll cede the floor to Mr. Colores.
okay. We'll let
Thank you.
that happen.
Good afternoon. My name is
Afternoon,
Peter
sir.
Colores, and we're here today to discuss three issues, and only three issues, that were the basis for the denial of Mr. Calderon's cultivation registration application. The first issue was the registrant provided inadequate evidence of cultivation prior to May 10, 2016, commensurate with the area proposed to be cultivated. Second, the registrant did not have a valid lease showing that he had lawful possession of the property on which he intended to cultivate prior to May 10, 2016. And finally, a site inspection revealed numerous significant code violations and other violations of law on the property well beyond the application deadline. So I'm going to take these in the order they were just presented. while prior cultivation would clearly demonstrate compliance with the code, this is not the only way to meet the requirements of the code. The key issue here is that the applicant did not provide evidence showing either cultivation or preparing to cultivate commensurate with the area to be cultivated. I'm going to repeat that. This is very important. While prior cultivation would clearly demonstrate compliance with the code, this is not the only way to meet the requirements of the code. The key issue here is the applicant did not provide evidence showing either cultivation or preparation to cultivate commensurate with the area to be cultivated. Those are not my words. Although I agree with them, those are the words in the staff report. And they're right. My client can cultivate, can show evidence prior to May 10 of cultivating, or he can show evidence of preparation to cultivate. Cultivation is defined under the Business and Professions Code as any activity involving the planting, growing, harvesting, drying, etc. of medical cannabis. So, stated another way, the key here is that the applicant did not provide evidence showing either planting or preparation to plant commensurate with the area cultivated. He can do one of two things. He can show evidence of planting, and he can show evidence of preparation to plant, which is what he did. As evidence of that, he submitted several photographs depicting the inside, the interior of the proposed site. Staff agreed, stating several photographs were submitted that showed some renovations in the structure, including rolls of carpet stacked in the corner. Those rolls of carpets were shown to exist in August of 2015. They were gone subsequent to that, and the clear plastic sheeting that is described here is actually mylar and is used specifically for cultivating cannabis. In fact, it can be used as evidence to show somebody was attempting to participate in cultivation of cannabis evidentiary. So the county on the one hand is saying, you know, you gotta show cultivation prior to May 10, but on the other hand, they're saying, but not really, because you can show preparations to plant or preparation to cultivate, which my client did in no uncertain terms. The photographs don't lie, they speak for themselves, and they speak reams here. My client was preparing to cultivate, i.e. plant, prior to May 10, as evidenced by the photographic evidence and the receipts submitted that show thousands of dollars expended to that end. Secondly, the invalid lease. More perfectly stated, the registrant did not have a valid lease, showing that he had lawful possession of the property prior to May 10. Gentlemen, in California, validly, there are certain requirements that have to be met and satisfied in order to be a valid lease. One of them is there has to be a writing. And indeed, in this case, there is a writing. So let's check that box. Secondly, there has to be an identity of the parties. In this case, Thompson Properties, Ralph Calderon. We're going to check that box as well. Thirdly, the description of the premises to be leased, very clearly stated in the lease. We're going to check that box as well. Specify the time, amount, and manner of rental payments. Check, check, check. It's all there. Establish a definite term. Also there. We're going to check that box as well. 5 years. We have a valid lease. What the county is saying here is, yeah, you have a valid lease, but it has, you're growing too small of a site, you have too small of a grow for your business, for the building in which you're planning on growing. So in other words, your grow's too small. So we're going to deny you on that basis. This is a very silly interpretation of the requirement for a valid lease. There's no question that the lease in this case is valid. It gave my client possession of Unit C, and in regards to Units A and B, my client had a future interest in that space, which springs into existence at a particular date, August 1. So, my client's lease on its face shows it is valid, legally binding, in other words, in the state of California. The county is saying, however, that, you know what, again, the canopy size it can only be 8,000. You listed 10,000, you applied for a 2A type license, which is indoor 10,000, so your cannabis site is too small. Regarding number 3, the code violations. It must be noted that all of these code violations, like so many others, were fixed. They were all corrected, every one of them. My client corrected these prior to the hearing on December 22nd. At that date, those issues were moot. Yes, they were perhaps violations occurring subsequent to the May 10th date. However, they were corrected and noted so. So, what we have here is an applicant who presented evidence of cultivation, attempting to cultivate, plant, has a valid lease, building violations corrected, and yet my client's application was nonetheless denied. I think we have to note that the mandatory registration requirements for medical cannabis in this county, as set forth in Section 1795, 165A, et sequitur, states that by May 10, the applicant must declare maximum total canopy that is or will be on the cultivation site. Is or will be. The or will be language contemplates an event taking place in the future, after May 10, 2016, and is another way of saying or at some time in the future, as opposed to the word is, that's the present tense, and in this case refers to May 10, 2016. If the drafters of the ordinance meant only to say that the applicant must declare the total canopy existing at the date of the application, the clause or will be would be unnecessary and would have led to unnecessary and avoidable confusion when trying to abide by this term. The purpose is because the framers knew that actual cultivation by May 10 is not required. As previously mentioned, preparing to plant satisfies the requirement. It must also be noted that the original resolution presented to the Planning Commission in deliberation of the original denial included the finding of forth that my client submitted false or misleading statements in the application. It must be further noted that the findings of the resolution as of the 22nd of December meeting signed and fully executed by the department does not contain that language. It's void, it's vacant. There's no allegation or finding that my client at any time submitted false or misleading evidence or information. And I think that is very, very important for this body to recognize. That is because that's exactly what is being alleged here in all of these other things, that this information in this application is misleading, and it's simply not the case. So with that, I have presented my side of my client's argument, and if you have any questions, or if counsel would like to add anything further, I'm here to answer them.
Any questions by the board?
But by the way, I therefore respectfully request that this body not approve the denial of my client's application.
Thank you, sir.
Mr. Cloris, I do have some questions. May 1st, your client had signed lease and lawful possession of Unit C.
Yes.
And then you say on August 1st, signed lease and lawful possessions of Units A and B.
That is the future interest that my client had in those two parcels, those two units.
So when we have something from the San Andreas Fire Department dated October 27th, going into a whole litany of issues concerning these units, specifically I think A and B, as I'm seeing it, but he says very clearly A, B, and C. Your client had possession lawfully of units A and B.
He did.
Okay. And yet in the report out from our departments, we're finding reportable quantities, sufficient quantities of hazardous materials that weren't reported, multiple cases of same, and yet we're claiming, you're making the claim that your client didn't do anything wrong.
I'm stating my client did not make any false or misleading statements in the application.
Okay. So Commissioner Wooster, in his statement of having a signed lease in California is one thing, but having lawful possession is quite another. I have to absolutely concur with that. If you don't have lawful possession, you can't do anything in that location because you don't have a way to occupy it.
May I respond?
Does that make sense? Yes.
Well,
I would like a response.
Yes, of course. My client had lawful possession. There's no way to interpret this lease otherwise. He had lawful possession of 8,000 square feet in Unit C as of May 1st of 2016. That is a valid lease. That would be upheld in any court of law. On the issue is this writing, which purports to be a lease for the property Airport Road, a valid lease? Yes, it is, and it would be determined such by a court of law.
So having a valid lease and in essence lawful possession places the burden of responsibility upon the leaseor or the person holding that lease to any activity that's contained within that property. Am I correct?
The lessor is the property owner.
Okay.
You use the term lessor, and I just want to make sure we're talking about the same person.
My mistake. I understand where you're going. The point is that for our code compliance people to be on site where there is numerous code violations within portions of this leased possession, does that not create a problem?
Not when they're corrected. They were all corrected. The authorities, the property authorities signed off on those deficiencies. The problem was corrected.
And that's not what I'm seeing from all of the information that's been presented here from the visit on October 27th.
Well, I think the evidence will show that they were corrected. And I stand by that statement.
Yes, if you could enlighten us, please. I'm looking at board packet page 674 for the other commissioner, supervisor's reference. And 675. In fact, it's noted on packet 677, I don't know what page that would be for you, Mr. Cloris, but it actually talks about the options to abate, what it was going to take, and they had stated a reasonable time of no later than November 30, 2016. If your client was not involved in this activity, why would there be a need to even discuss this whole option of abating something that was a code violation with you if you weren't involved in it?
I'm not sure I understand the question. You're saying, could you please
Yeah,
restate?
I want to go back to what the options to abate. This is page 677 of our packet. Obtain permits and repair and install all safety equipment. All exits must be operational, accessible. It goes on with a list here. But it gives a date of November 30, 2016 in that. And this is something that's stated directly to Smith Thompson Property Holding about the alleged code violations. And evidently, the lease is in effect at that time, is it not?
Yes.
Okay. That's the only point I'm trying to make. Sir.
Supervisor Mills, just to speak to that briefly, as part of the evidence we submitted to the Planning Commission is a December 14th letter from Code Compliance.
Yes.
Stating that the violations on the property have already been addressed, and the substandard structure posting removed from the structures and parcel. So it is true, there were violations, and it's true that they were addressed and remediated.
Okay.
Which our position is, was the case with numerous other applicants under the ordinance, and the presence of violations and subsequent remediation of those violations well after May 10th, 2016 was not an impediment to their approval.
Okay, so maybe I should ask the question of, just to confirm, there was no actual cultivation on this site as of May 10th, 2016, correct?
In the sense of planted cannabis?
Actual plants
No,
growing,
there-
doing something on the site?
No, there was not.
So there was then, by admission, an intent to expand to the full 10,000? Am I asking the question correctly? That you had then submitted for and gotten at least started on the 8,000, but the intention was to expand to 10?
No. The fact that the 10,000 square feet shows up that's the maximum under the type 2A license that my client could operate under. 10,000 is the maximum. He's obviously confined to the physical limitations of the building of 8,000 square feet. If I'm not mistaken, it's an allowed procedure for a applicant to modify his application down from the size, the canopy size stated on the application to the actual canopy size, either vis-a-vis the structural, the size limitations of the fence or the building in the case of an indoor grow.
I may be asking for something that you're not quite aware of, but when did the physical growing begin to occur on this site? You don't have to answer it if you don't know.
Well, I don't know, nor is it relevant, because to satisfy the code, all he had to do is prepare for planting, prepare for cultivation. So the question asking when he actually cultivated, I think is getting us away from the actual issue here and the facts, that he was making preparations, substantial preparations to plant in that building. Now, you'll notice in one of those photographs, there are rolls and rolls of carpet. Those carpets weigh hundreds of pounds. They need heavy equipment to be moved. Very similar to a fallen tree on an outdoor cultivation site. Now, if this were an outdoor cultivation site and he were removing the trees to allow him to prepare for planting, I think everybody would agree that this falls squarely under one or two of the requirements. But this is not an outdoor site, it's an indoor site, but it's analogous vis-a-vis the fallen carpet rolls on the property which needed to be moved in order for him to do anything, which he did. So we did provide evidence, substantial evidence, clear evidence, and convincing evidence that my client did prepare for cultivation, i.e. planting, and that's not to be understood to only mean planting before May 10.
Okay, so maybe I need to make a disclaimer here that my wife and I have been involved in the carpet industry for literally decades, so moving rolls is not a big deal. Okay. I just making a point that it's not like trees. There are forklifts that are designed specifically for that. We can move hundreds of them in a day if we need to.
You're absolutely right, but I think to mitigate or downplay the significance of the obstruction of the cultivation site, because a heavy lifting machine can move those out of the way, I think is minimizing the efforts that needed to be taken to prepare the site for planting, and I
Okay. I appreciate your responses. Thank you.
Any other questions? Supervisor Garamendi?
I have not been involved in the carpet business, but I'm also not a lawyer. I feel very, let me ask you a question. In the photo there, it had August 12th, and there was a forklift and a bunch of carpet rolls. How much canopy was actually grown on this site?
I don't know the answer to that question.
Is the owner?
I'm not sure that that is relevant to the issue here.
You don't want to answer my question?
I'm not saying that. I'm just stating an objection that I don't think is relevant, but.
Microphone, please, sir.
So Supervisor Garamendi, the question is what
How
square
much did
footage
you
was
actually grow?
in Unit C? Between 1,500 and 2,000 square feet, depending on the stage of the plant cycle.
Who were who employed the employees that weren't your employees on the site that were put in the dangerous working conditions? Your client told you that he had half an employee that was visiting there on occasion. So who employed these people that were having to work in an unsafe environment?
Preliminarily, I don't know, as I sit here, the answer to these questions. And I would further submit that they're a bit beyond the scope of this hearing, which is to focus on the findings of the Planning Commission.
Well, number 3 was about code violations for our county, wasn't it? I'm not arguing the first 2. I'm asking, there were clear violations of state and county code in this building. One of them is unsafe work environment. Lots of pieces go into that, so I'm wondering who's responsible for the life and safety of those people that were working there.
That's a question I can confer with my client about. I would just, more generally, as a procedural matter, point out that we have proffered hundreds of pages of new evidence, which has been summarily rejected by this board and declined to send back to the Planning Commission for further review. And this, too, likewise, would constitute new evidence that the board is requesting.
Well, we've already have evidence that the fire escapes were blocked. We have evidence that you were running generators indoors with fans. We have evidence that people were illegally habitating this place, correct?
It's my understanding that
That's already in the thing. So my question is, who do you think is responsible for that, for the life and safety of your workers?
And my response, with all due respect, would be that's beyond the scope of.
That's fine,
issue
Counselor.
excuse
That's
me,
all I
but
need.
that, Mr. Garamendi, that issue was addressed at the Planning Commission, so I think it is relevant. It is ability to revisit that question because that was raised at the Planning Commission hearing. Who was responsible for the employees in Units A and B?
And I mean, one point that bears mentioning too is my understanding is this is the subject. At this point, we're talking about the subject of an active, ongoing investigation that I understand is currently being conducted. And it'd probably be unwise for us to proffer live testimony from our client unprepared on a subject like this at a hearing of the board.
I have no further questions.
Thank you, Supervisor. Supervisor Toffenelli?
I have a couple of questions. You're testifying that there was only one part-time employee employed, and that part-time employee was doing all the renovations to this building in preparation for him growing 8,000. He moved all the carpets, he hung all the Mylar, he's putting in all the lights, he's doing all this. One guy working part-time?
I think there may be a misunderstanding as to time frame, but let me, again, these are all factual questions that I don't, as I stand here, know the answer to. We can, perhaps if there's we can write down the factual questions, confer with our client, and respond. Would that be?
Whatever you need to
Okay.
do. I'm just looking at the pictures, I'm looking at the amount of work here and the time frame stamped on these pictures, and I'm thinking one guy working part-time wasn't doing all that work. And preparing this for grow. I mean, when you talk about grow, you're talking about putting all these lights in, you're talking about hanging all this Mylar that he's doing here, you're doing preparations to this building in a couple days with a guy working part-time. I don't see it.
Sure, and to avoid playing a game of telephone, Supervisor Toffenelli, we'll just let Mr. Calderon answer that question. Is that all right? Okay.
Would you please state the question again?
I'm saying that it was testified and given as evidence that you had one part-time employee that was working there. And the pictures show from the time frames, stamps on them, that there was a substantial amount of work going into preparation to get to May 5th when these things were done, the final picture was taken. And it just appears to me, if that guy's available to work, I'll hire him at the amount of work he's done here for being a half-time employee, because I have employees, and so I'm just wondering, you know, how could this be done in that time frame with somebody working part-time?
And in terms of for example, the Mylar, I did that by myself. I put up that Mylar myself, and it took me a couple hours to put that up. But there was other work done myself with my employee, and also which I've submitted for the electrical permits and some of the permits that were approved in early November after the code compliance inspection. There was an electrical subcontractor, and that also did work there, which his information is all submitted, and he actually has a permit. And
So you had
a closed
contractors
permit.
doing work also?
A closed permit on that,
You contracted
some
to work
stuff.
out?
I mean,
Okay, all right.
you know, I don't know the extent of the work that we're envisioning, but what's done there, yes, very feasible to do with the crew that I have.
Okay.
And one other thing I would like to mention, because I heard a November 3rd date and some things, I was never made aware of any of the code violations, and the first time we were made aware in writing was on December 15th, I believe, when they sent a letter to the landlord. And in the letter states that we were never made aware. The only information that I have is from personal meetings, which is in one of the letters that Mr. Lambie sent over also. Personal meetings and requests personally to code compliance, and I had a meeting with planning and with code compliance. It was given to me verbally. Items were corrected, and I received the permit on a Friday. That Monday I had inspection and closed out all of those items. So, you know, and referring to one of them that state November 3rd, on November 14th, I send an email to code compliance asking for the letter, or maybe on 13th. The following day, I responded. I re-forwarded, hey, any news? I haven't heard back. And on November 15th, I am told that there is no information yet. There isn't a list of violations yet. So that is on November 15th. So, you know, I did as much as I could, proactively as possible, and got every item that was mentioned to me taken care of in a matter of 72 hours, including permitting. Thank you for your time.
Any further questions, Supervisor Toffenelli?
No,
Permit.
not at this time.
May 9th.
I have a couple of questions, sir. Going through the board packet, I noticed that you have a California driver's license. Your client has a California driver's license. I also noticed he had an address in Florida. Okay. Also going through the board packet, I noticed a permit application. Give me a moment so I can get to that page. My computer scrolls a lot slower than I do.
As you're looking for that, my client has a residence in Valley Springs and maintains a residence in Florida, operates several successful businesses in Florida, as well as here in Calaveras County.
I found the driver's license, okay.
And he's a graduate of Purdue University with a degree in business management. Proud son of immigrants.
One moment, please. Sir, who is Smith Thompson Property Holdings? Do we know who that is?
I believe, are you asking me?
Yes.
I believe that's the entity that owns the property that's subject to the lease.
Okay. Mr. Colorado, you said you pulled permits for the electrical work? Is that what you testified to?
Yes.
Okay. Do you know when you pulled those permits?
The property, May 9th, I believe the property owner pulled a meter electrical permit to assist me in work that was being done, future work that needed to be done.
I'm looking at a document from Calaveras County Building Department. I don't seem to see a date on it, other than, that's the date of the check. I see that it's a work description, a 200 amp service. Is that for your facility?
Mm-hmm.
That would be Unit D?
That's how
Is
they,
that- is that how
for
they
some
did
for some
identify
reason,
it?
that's how they put it on the meter box. I don't know why. That's how PG&E gave it.
What was the business before you took possession of this property?
Of the entire building, or
Well,
Unit C?
how about Unit D?
Unit D, it's an A, B, and a C.
I'm sorry, what?
There's an A, B, and a C.
I'm sorry, I didn't understand you.
There is a unit A, B, and a C.
He's not aware of a unit D, since the lease describes
Oh.
units A, B, and C.
But you did have a 200 amp service in that
200 amp service.
installed?
We have multiple 200 amp services on the property.
And this, apparently this was paid for by check by Smith Thomas Properties. It indicates the Unit D is a carpet warehouse. Do you have any knowledge of that?
I have knowledge of.
Why would this be in the board packet? Was this submitted by you or by your,
My previous attorney, perhaps, document.
it's dated, the date of payment was May 9th, 2016.
Okay.
So was this work done at your direction or for your occupancy?
By the property owner, I would
Uh,
have,
uh,
the
if the
property
property
owner
owner
was
is
the one that
Smith
wrote
Thompson.
Smith Thompson wrote the check. I don't know what their thinking was. It had to do with upgrades for the property, for the use of the property. I think the lease is pretty clear on the intentions of, the property owner in mind with use of the property, with any other tenants, anybody else. I can tell you that from my standpoint, everything that was done was for the cultivation, yes, sir.
Was that a condition of your lease to install 200 amp service? Do you recall?
A condition of my lease. I don't know the lease inside out. I couldn't tell you if it's a condition of the
Counsel, are
lease or
we
not.
still in the boundaries of the appeals commission here? Hearing, I don't want to get out of this.
I mean, it's,
Yeah, okay, I'm aware of that. Okay, thank you very much. Yeah. Any further comment by appellant or counsel?
What's that?
it's necessity for my use.
Any further comment by staff?
I would like to address some of the points made by the appellant's counsel on this. He made a statement that we denied the application because the cultivation area was too small for what was applied for, and that's just simply not correct. We denied the application because the area that he was cultivating in exceeded the area in which he had a valid lease and which he had prepared prior to May 10th. And the reason why we referred to the 8,000 square feet versus 10,000 square feet was simply because at that time, when the operation was shut down and we denied the registration application, he was utilizing the whole of the building, all 3 units. But the lease only gave him possession on May 10th of Unit C. There were other businesses occupying A and B at the time. So he couldn't have had occupancy or making preparations in those 2 units for the cultivation that was occurring. And that was the point, and that was the reason why it was denied. Yes, if he'd come to us earlier and said, I'm only going to cultivate in Unit C, I want to reduce my cultivation area, we probably would have okayed that. That was consistent with our actions elsewhere. But to expand beyond an area that he had the rights to on May 10th would be no different than someone outside saying, well, I'm going to expand into this other area that I hadn't previously prepared, I hadn't worked on. I was leasing that property to someone else at the time, but now I want to grow there, so I'm going to expand the cultivation area. That's clearly the opposite of what the board's intent was with this ordinance. And the reason it was denied, not because it was too small, but because he was cultivating in an area that he didn't have possession of on May 10th. And that was the basis there. The is or will be language, and I discussed this in my presentation, and Mr. Clark has brought that back up, does not provide the ability to sort of expand your operation as you would like to. The ordinance allowed a grower to cultivate what had been cultivated previously, or if the site had been prepared, graded previously, then that will be language was anticipating that where someone had graded an area in anticipation of cultivation, that they could plant their plants there. On May 10th, a year ago, it was still early for plants to be put out into the environment, and so people had prepared the site, getting ready to put plants in the ground or in pots, and the board anticipated that, but the caveat was you had to have prepared the site beforehand, the site in which the plants were going to go. Not later on, well, I only had 5,000 square feet, I wanted to grow 22, so I'm going to grade this other area over here and put plants. That was not permitted. There seems to be some misunderstanding that if you were growing a certain amount, that you had the right then to expand after that to the full amount that's allowed. Absolutely not true. What was allowed was what you had either cultivated before or graded for. I've used the term prepared in a general context. But in this case, there was no way for the applicant to prepare units A or B because he didn't have access to them. He could have got into the building, but there were a gymnastics studio going on. He couldn't have, start installing grow lights and Mylar while the gymnastics studio was in operation. So that was the basis for our denial, was that he didn't have access to that area. He hadn't prepared the site. Now, the Planning Commission didn't use the term prepare. They found that the ordinance itself required either cultivation or grading. That was different than what was in the staff report where I talked about preparation. The Commission's finding was the ordinance is very clear. You have to have one or the other, grading or cultivation, neither of which occurred in this site. Finally, as it comes to the, whether or not Mr. Calderon had direct oversight of the individuals that were working in there, he's responsible. He was the lessee. That would be no different than if someone was working on my property and I didn't, I hadn't hired them, but they were doing something illegal on my property, I would be responsible. He's a responsible party here. He should have known what was going on in the buildings that he was leasing. And there was illegal activity going on in there. That's the third reason why the Planning Commission denied this request.
Thank you. At this time, there's an opportunity for rebuttal, or subbuttal, if you will, by the public. Any member wish to speak on that issue? No, seeing nobody. Submitted by counsel for the appellate, submitted by staff. Any further comments?
Just make a couple comments in response to what the director said in closing.
Okay.
This issue of prepared size versus application size underscores to me the importance of comparative analysis looking at other applications. Those applications, as I alluded to earlier, contain numerous instances of the applied for size significantly exceeding the prepared size and no denial occurring on that basis. With respect to the activities that Mr. Maurer is alluding to in units A and B, I would leave this body with 2 points. One is that at the time those activities were the subject of an enforcement operation, this application was still pending for all 3 units. I understand that today, as we sit here, we know that there was a denial that hinged in part on the exclusive possession of units A and B. That knowledge was not available initially. And so bear in mind, too, that this A, B, and C were all the sites of a pending application. But more fundamentally, the idea that there was a host of unlawful activity going on, there were clearly code violations. There's no denial of that. And there's no denial that Mr. Calderon took full responsibility for those code violations and remedied them promptly, which is an opportunity that was afforded to many applicants beside himself. But he did that. And the idea that there was some vast illegal operation going on there has not been confirmed by any criminal convictions, has not even been confirmed the subject of criminal charges, as far as I understand it. There's an ongoing investigation, which is part of the reason why it's difficult to discuss the specific facts at this time. But my client, just like everyone here, is entitled to a presumption of innocence until proven otherwise. So the idea that there were code violations, absolutely. The idea that those violations were promptly addressed, that's documented in our materials. And as I said earlier, other applicants, and that's why I think the importance of this comparative material is so high. We're routinely given the opportunity to correct violations well after May 10th, which is a privilege my client was not afforded. Thank you.
Thank you.
Thank you.
With that, I'll be closing the hearing that I reopened. And we'll bring it back for board discussion, deliberation. Any comments by the board or any deliberation?
It's interesting in the site, Mike. It's interesting in the commercial site registration form, this is item 22, it says cultivation site habitation, check all that apply. It says my site will remain vacant with no one ever staying overnight. And it's checked yes. So I just wanted to bring that point out that's just in case somebody had missed it in the discussion.
Any further comment by the board? Hearing none, I'll entertain a motion in regards to this agenda item. And the motion would have the content in the form of upholding the decision of the appeals board from the Planning Commission. Am I correct with that, counsel? I want to make sure we're totally squared away.
Would you like me to restate it?
Would you please? Thank you, Madam Clerk.
To adopt a resolution upholding the Planning Commission's denial of 2016-1123, appeal of the Planning Director's denial of commercial cannabis registration 2016-106, filed by Peter Coloris for Rafael Calderon and Mountain Farms, Inc., at 833 State Route 49, San Andreas, T4N R12E, Section 20, APN 044-006, 2022-028.
Okay. Everybody clear on the item issue? I would at this time entertain a motion.
Mr. Chair, I would move to uphold the Planning Commission's decision.
Moved by Supervisor Tofinelli. Do I hear a second?
I would second it.
Second by Supervisor Mills. We've already had public comment on this. All in favor indicate by saying aye. Aye. Opposed indicate by saying no. Motion carries 4-0, one abstention.
We need somebody to go get our supervisor. He's in the hallway out there.
It's one absent.
Okay, well, can we take a 5-minute break?
Yeah.
Just to clarify that the vote was 4 in favor of upholding the
Four in
the
favor of
denial,
upholding and one abstention.
absent.
Absent, I'm sorry. Absent. We're going to take 10 minutes, folks. Okay, ladies and gentlemen, Madam Clerk.
Supervisor announcements. In compliance with AB 1234, chaptered as Government Code Section 53232.3D, this is the time for board members to report on meetings attended on behalf of the county and to carry out their duties as a county supervisor.
I believe we'll start with Supervisor Tofinelli. Would you like to lead?
Yes. My microphone on here. I would just like the opportunity to talk a little bit about the ordinance that this board directed staff to put together was released last Friday. And there's a public comment period before it goes before the Planning Commission, and then before it comes to us. And I would just like to encourage people to on both sides of this issue, I think it's important that both sides submit to the planning department or even submit to their supervisors ideas on what they'd like to see this ordinance look like when it's finalized. You know, I can't tell you what it's going to look like now before it comes to this board. I can't tell you what the recommendations of the Planning Commission will be. I don't have a crystal ball to look at that. I think it's very fortunate that we have, when it's going to be coming to us, it'll be about the same time the preliminary budget will be showing up. So we'll be able to be looking at both of those on when we address that issue. But I think, and I'd like to pull the board on whether we would like to entertain possibly some type of study session, allowing the public to come up and talk and give their ideas and what they would like to see in this ordinance, and give us ideas to look at or think about encompassing in it when it does get to us. And possibly some of that could be going to the Planning Commission, and on both sides of the issue. I know that there's concerns. I have this I guess you could call it habit, for any less lack of another word, is usually I'm not a big social media person at all. I don't go to these sites and all the time on my phone or on the computer looking what everything is. But, you know, sometimes on a Sunday morning over coffee, I'll go on to some of these sites just to be informed on what people have to say and what's being said out there. And there's a lot being said on both sides of this issue. There's some things that they'd like to see in this ordinance. And I would like to see if the board would like to entertain that. And I would like to encourage everybody to come forward. And this is your time as the public to be heard on what your visions are and what you would like to see in it. And if you don't come forward and you don't put anything in paper and writing or an email or send it to planning or step up here and say what you would like to say, then you're holding your own voice back. You're not making your statement. And this is America, and everybody has a right to say what they'd like to say, and not feel afraid or feel threatened that they're going to be ridiculed or somebody's going to threaten them on what their beliefs are and what they have to say. And it seems to be on this particular issue that sometimes it's going down that path that people are afraid to say on either side. And that is making us, in my opinion, a third world country where you are unafraid, or you're afraid of making your voice heard. And that's not right, because there's been many people that gave their lives or fought wars for us to be in the position to be able to be free enough to say our piece. So I encourage everybody to do that, and I would like to, again, pull the board and see if we can put together some study session where at least we can have the public come forward and give their thoughts on how they would like to see the final ordinance look like when it's presented, and finally for this board, in adoption for this board.
Does May have a fifth Tuesday meeting in it?
Yes, it does. It's an evening meeting on May 31st.
Would that be a good place to put it?
I would say so, yeah. I'm
And
in
just
favor of
make that the meeting for that date and nothing else?
Yeah.
Supervisor Garamendi?
I think May 31st, and we have an evening meeting where we can do our regular business. I think the idea of having a focused study session, lack of a better term, where we can, I think it'd be important if we set this up so it doesn't become a popularity contest of how many people get up, but as Gary pointed out, concrete proposals. Here's what I'd like to see.
Exactly.
I'm very encouraged to know that there's Supervisor Tokenose and other people hopefully are open to the idea that the ordinance, the way that it's written now, is a total ban, is something that's not set in stone. It's something we can negotiate around, and that's why that'd be the purpose, I assume.
Okay. Supervisor Clapp? Polling the board on a study session on May 31st?
Yeah, I like to
Reviews?
have input. I like to have input myself, because I think the public's had more input than the supervisors at this point. But I'm still for the ban on it, so if it's a study session that we can maybe make it other than a ban, then I'm not for that. But I'd like to hear what people have to say, but my position's pretty firm on that, but I'd like to have some input on, we got Prop 64 we have to deal with, how we can do that. I mean, there's a lot of stuff that we need to do, but on the commercial part, I'm pretty well set, so if they'll be just wasting their time with me as far as I'm concerned, but there's a lot of stuff on 64 that I really wanted to address, because, everyone's act like we're really taking their drugs away from them, but it's still there at 64, and we can't do anything about that, but there's things that we can do to make it better on the neighbors next to them and stuff like that, and so, yeah, I would love to address 64. So, yeah, I would, and I would like to do it on the day that Gary said on our meeting, that night meeting, because it's better for the people to get there, and so I'm for that.
We may have to change venues simply because of the potential for crowd size. We've done that before.
Madam Clerk, do we have any idea what the calendar looks like for the 31st of May?
We're not to that submittal deadline yet. That's like 2 weeks before that meeting. So at this point, it would be really hard for me to, I bet if I look, there'll be nothing. Just to keep in mind that if we change venues, we cannot live stream.
Okay.
So,
County Council, any comments on this? The microphone, sir.
It's too early to ascertain, how thick that agenda is going to be. It could be very minimal. But if you're talking about a study session, that means you're doing something before the night meeting. Is that my understanding?
CEO Lutz, any comments?
No, I also think that certainly that evening meeting provides better access. We could request the departments hold off on anything that's truly not urgent for that meeting, and move it to either the meeting before or the meeting after, to make sure that we can leave time for just the study session.
Okay. Thank you, sir. I also concur that a study session would be in order for this. I do wonder, I know that Mr. Mauer has left the chambers here, but my concern on the EIR that's due to come out, and I don't know when that's going to be here for a solid date. Do we have any idea on that? Microphone, sir.
It might, my understanding is that might happen before then, but that's okay, because the EIR addresses many different scenarios, so there's no incompatibility.
Okay.
And my last understanding was that that EIR should be completed this week, toward the end of this week. So I would anticipate it definitely would be out at that point.
Madam Clerk, you-
Just as a note, I believe Mr. Mauer is out of town that week. He will not be here.
okay. So from the consensus of the members of the board and staff, looks like we can make that, short of the problem that Mr. Mauer may be out of town.
If I might, Mr. Chairman, I just want to make sure, and to Supervisor Clapp's point, he doesn't want to waste anybody's time. If we're just having a special meeting to debate whether we have 6 plants in a padlock structure or 6 plants in a chain link fence structure, I don't think that's worth it. But if this board is willing to have a broader conversation about cannabis and what we can and can't do, I think it'd be very much worth our time. But I think we don't want to waste the public's or our time, as Supervisor Clapp pointed out.
Mr. Mauer.
Surprise.
Boy,
Since you're running.
so how fast do you run 100 yards in?
Not as fast as I used to. Heard my name taken. The final edits to the EIR were given to the consultants. Excuse me, catch my breath.
You can catch your breath.
Catch your breath.
The official start of the public comment period will be next Monday. We have to file the notice of availability, but it is done. I hope to have copies to you this week, hopefully by tomorrow or Thursday. A question for you, would you prefer it electronically or in hard copy?
Electronically for me.
Electronically for everyone? Okay, good. It saves us cost of printing.
Okay.
So as soon as that's available, I will send you a copy. We'll be posting it on our website, there you have it.
Thank you, Mr. Mauer. Thank you for coming back so
Sure.
quickly.
You're not going to be available, you're on vacation the week of the 31st, is that correct?
I will be gone the last few days of May and the first few days of June that week, yes.
I better see if I'm going to be here.
Okay. Was there something happening that I should be here for that?
We were talking about a study session
Oh.
on the ordinance.
That's right.
If you have plans,
There's a night meeting currently scheduled.
Oh, okay.
Okay,
Yeah.
I'm available. All right, I would concur with that. You'll have someone from planning if we decide to go ahead with this, right?
Yes, I think that, we can make sure there's some here to provide input into that.
have Ethan also.
Yeah, County Council's office has been very involved in the preparation of that, we've worked together along with environmental management staff as well.
Peter, I'm doing the board on the 31st, so if normally you wouldn't send me that document, but send it to me too.
Okay.
Okay.
Okay, excellent. Anything, excuse me. Anything else to report out, Supervisor Toffenelli? No, that's it. Supervisor Clapp, any reporting out issues?
Yeah. I've been up here for nearly 40 years. I remember when I first moved here, we had a neighbor on a half-acre lot that had 3 hogs, and that took up months of the board's time. And it actually went and was litigated, and I went from goats to sheep to horses to 4 years ago or 5 years ago. I don't know if Gary was on the board when we had Rooster Man coming over here. You were on the board then? And I'm just amazed that this continues on and on for 40 years and we've never done anything about it. And the amount of time that all the previous boards have put in on this, that something that could be really simple done. And I would like to go ahead and get that started. I'd like to get something done on it. Yeah, I don't think it'd be that complicated, take that much time. And I have a friend that's a retired professor from the University of San Francisco that was an environmental health teacher. And he's already did a structure for it real quick. and I dropped that off at the environmental health. And I'd like to get that started, and we can change Title VI where we won't have these people come in front of us because their neighbor in La Catena has a rooster. And so I think it's something that's way overdue, and I'd like to see the board, I'd like to get permission of the board, we can start doing something like that. I'd like to pull the board.
Could you clarify what you're proposing?
I'm proposing to update something that's probably like 50, 60 years old.
What's something, I'm sorry?
Something would be, for instance, we had an individual one time that had 100 or some roosters next to him. And we spent months in this. I mean, we actually started calling them Rooster Man. We were on the front page of several newspapers and stuff. I mean, it was a joke. A half-acre lot with 4 or 5 hogs on it in a RR zoning, or 2 dozen goats or something in an R zone. A couple 100 chickens, on it. So there's been huge problems that went for a long time. I'm not talking about ag, I'm even talking about some rural residentials, like in Rancho, you have rural residential that are half-acre lots. And, and we need to do something because we have horses going and stuff, we got heavy traffic and stuff. And there's a lot of things that need to be addressed, and it's not that we need to do it. I mean, we can't just keep on letting this go on, and then the people come up here and go, hey, my neighbor has 200 roosters. What are you guys going to do about it? And it's not just once or twice. It's been going on for 40 years. And I think if you live in a residential area, not a rural residential, I think if you move into a golf course or something, you're moving there to not be a farmer. And so if you have a quarter-acre lot, you shouldn't have 2 or 3 horses on it.
I'd be open to that, but I'd also be cautious because obviously we've got kids that have 4-H, FFA. People are into having a couple chickens in their backyard now. So I'm open to the conversation, but we should be cautious.
CEO Lutz, can you put that on your list of things to do?
Yes, I will, and I know that this has taken, I'm sure Mr. Sirius would weigh in, that this has, some of these issues have taken quite a bit of council's time too at trying to work through with some of the practices that are allowed in traditional residential ordinance or residential zoned areas that are within the ordinance. So I do think we need to look at the ordinance and come back with maybe a set of recommendations, go out to the communities. I think, as Supervisor Garamendi points out, with changes in how people want to have, a few chickens in their backyard, etc., this is going to become an increasingly bigger issue, I fear, if we don't do something. And we'll probably need to do some community meetings to garner input from impacted residents.
Okay. Thank you. Supervisor Mills.
Okay, Wednesday, April 12th, staff attended the Calaveras County Water District meeting on the final formation of the Groundwater Sustainability Authority, JPA. I attended the Sam Joaquin Groundwater Sustainability JPA, as the county is to have an oversight role in the Sustainable Groundwater Management Act. CCWD is going to take the lead role in the county, and Valley Springs Public Utility will have to join at some point. They haven't done it yet, but we need to have our formation done by June 30th under state guidelines. I met with interim director of the Council of Governments to review county projects and funding, focusing on delivery of projects of the county and the reporting structure, and that evening interview on public television Inside View. April 13th, Thursday, attended Murphy's Sanitary District meeting, discussion on how to resolve spills and possible joint discussion with CCWD on solutions for the longer term. I'm sure Supervisor Olivero will be interested in that. Attended Planning Commission meeting after lunch, attended grand opening of the Chamber of Commerce at the Resource Center here in San Andreas, and attended Copperopolis Fire Department meeting that night. Friday, April 14th, met with the CEO and staff to review some challenges and meeting goals. Thank you for your time, CEO Lutz. April 15th, Saturday, attended Community Services District Number 2 road meeting, looking at some grant sources and funding opportunities for repairing storm damage. Attended the Spring Fest at Coppertown Square. Monday, April 17th, met with former CAO, retired from another county, on how, now living in Calaveras, over a broad range of topics, and met with the CAO over my take on short-term goals. Attended the Solid Waste Task Force meeting Tuesday. Staff attended CCWD Finance meeting in the morning. Wednesday, Calaveras, Amador, McCollum River Association meeting, where the board took action to oppose AB 975 Wild and Scenic Rivers, which supports the position of CCWD, mountain counties, and other water agencies. April 20th, Thursday, attended final session of new supervisors training hosted by CSAC in Sacramento, with most of the newly elected county supervisors in California. Staff attended the Treasury Oversight Committee meeting for me, where it was noted no new supplemental taxes have been worked in the last 7 months. I just want to let that sink in. Leslie's checking with other counties experiencing tree mortality as it relates to property valuation. Attended Calaveras Foothills Fire Safe Council to see the results of the GIS work and maps that have been worked on over the past years under grant, past 2 years under grant by Central Fire, and I have a copy right here. And what it has a little square down here, and if you're a remote or an agency that doesn't work in Calaveras County and you report to a fire, you can get on your cell phone, and if you got G4 connection, you hit that, and the minute that you do, they will identify you by GIS as to where you would be on this map. So they have in real time on the IC command system a knowledge of who's where, and will be zoomed in because we're going to do another overflight in June, so that they can have pinpoint accuracy. And thank you, and Supervisor Garamendi's district, it's Central Fire that has done a lot of this preliminary work, and I would like to see the other fire agencies get on board. And this is with the assistance of CAL FIRE. They're also working on this as well. So thank you to especially to Patty Raggio for her work in putting this together. Then looked for, I had the staff attended the Chamber of Commerce mixer and the ribbon cutting at Mind Matters in Murphy's. I think you were there, Supervisor Oliver.
I was.
And Friday, April 21st, met with Community Services District 4 over storm damage options, and members of the Emergency Animal Recovery to look at OES coordination and incidents. I met with Melissa at the Council of Governments to look at options for our Independent Road District CSD2 for assistance in repairing storm damage. I met with CCWD and Brian Moss to report out the progress of the San Joaquin Groundwater JPA, with emphasis on the county's work to complete their portion of it. Saturday, April 22nd, attended the fly-in at Calaveras County Airport, and also attended Angels Camp Business Association's Taste of Calaveras at the Count's Winery in Murphy's. I think I'm out and about in my district. So people think I'm not doing stuff. I would also ask at some point that possibly discussion was brought up by Mark Whited this morning in public comment, that we can bring this back on the agenda to discuss what he was talking about our representation ratio in California, and whether or not the board would be entertained that at some point in the future. It doesn't have to be right now, but
I would go for that.
you would.
Yes.
Just to have that discussion, and if we want to move forward with it, at least to see where everybody is.
Thank you, Supervisor
That's all
Mills.
I have.
Supervisor Garamendi.
Thank you. I'd like to echo Supervisor Mills' statement about Central Fire and the great work done by Patty Raggio and Chief Stone. And now with the additional imagery that will be provided by the county, I think it's a great opportunity for all of our fire districts to get on board, and hopefully we could support the fire safe councils in their efforts to fund these projects. I've had a tremendous amount of meetings with constituents over the last week, since last Tuesday. Whether they're for a ban or against a ban, they're all very concerned about how we fund public safety, and District 2 in particular. And so I'm very happy to hear that, and maybe I should confirm that people are open to something other than the scorched earth ban that currently is moving forward. That was directed by the county, which is to the maximum extent of the law. And I want to make sure that that's what we're going to spend the 31st doing, is having that conversation, not just about how we could make things work and how we could fund any direction that we go. So is that the page that this board's on?
I'm on that page.
I think it's just a matter of wanting to look at this ordinance, maybe even possibly line by line, and saying, is this line something we can live with, or do we want to have a restatement of that line to better clarify, so that there's no misunderstandings or false conclusions about the ultimate objective we're trying to reach?
So, I'm sorry.
I'm going to get back.
Can you unpack that just a little bit, Supervisor? I'm sorry.
Take that out of the suitcase and break it
Tell me what
open.
you're saying.
Because I'm sure that as everybody looks at this, there's going to be a certain section and a paragraph that they feel that isn't clear enough, or that needs more clarity, or that there's some piece of it that they're not comfortable with. And we need to actually look at what those are, because at some point, those are the areas that we're going to see our greatest amount of pushback because of misunderstandings, misconceptions, or what is it our ultimate goal is. So if we haven't settled on what our ultimate goal is, then the ordinance in itself and the work that's been done in the ordinance really isn't clear at this point. It's just a summation of what staff thinks it ought to be. Is that true? That's the question.
Our staff, we directed staff to create a ban to the maximum extent of the law.
To the minimum, to only comply with the minimum required by the law.
That's correct. So
Right.
is this board willing to change that position?
I'm not.
I haven't stated that. I've been willing to change it.
Okay, we could,
The only thing I was
we
requesting
could-
is
we-
a study session there's no action taken.
No.
That the public could come forward and give their views on the ordinance and give what they feel needs to be inducted into it, the public input portion of it. That's what's up for right now in the next 45 days for this, and for the ordinance before it goes to the planning commission. So I'm interested in hearing what the public has to say. That in a study session arena, which you cannot take an action on. You can only take in information. That's what I'm interested in, and that's what I was proposing. And then we could, at some point, when it comes to us, have those notes from the study session and have the planning commission's recommendations, and we can discuss that when it comes to us at the board level.
I think ideally, I would like to ask the public, if they're going to provide input, let's not go running over ground that has been run over now for the last 2 years. Give us new and compelling arguments. Give us things that we haven't looked at. Give us ways that we haven't looked at it before. Give us new information, and allow us a full and complete discussion on this rather than always going back over the same issues over and over again, knowing that we're not going to really see much of a difference in the result. And I'll rest my case.
all right. Gentlemen, I think that's a good idea, as long as we stick to the purpose and our goals. And that is to, number one, hear from the public.
Correct.
I understand the concerns that Supervisor Garamendi has, and Supervisor Mills, and Supervisor Clapp, Supervisor Tofinelli, but once again, let's hear from the public, and let's hear reasonable, constructive ideas. Being aware of both sides of that argument, if you will, because there's always three sides to an argument. But the bottom line is, it's a fact-finding study session for the board, because ultimately we're going to be making that decision. And my position as my fellow supervisor is to get all the information I possibly can on both sides of that fence before I even commit to making a decision. Is there anything else on that issue that we need to speak about?
I just don't want to waste people's time.
I understand. And as chairman, I will try to keep things on track, and hopefully we can be constructive and get some things done. With that, changing horses here, if you will, I can tell you what I did. Basically, I did, after our last board meeting on last Tuesday, I attended a tri-dam meeting with staff and Supervisor Mills, gained some information on that and where we're going on that. That's going to be a pretty involved situation. On the 19th, I attended a Forest Meadows homeowners board meeting luncheon and was able to, once again, spend some time with the folks up in Forest Meadows, find out their concerns. I plan on doing that quarterly with Forest Meadows at their request. We found it very constructive, exchange of ideas and chance to sit down with a supervisor so they can throw things at you. No, just kidding. They didn't throw nothing at me. They did a good job. I also attended and made a presentation at the Arnold Lions meeting that day, dinner meeting, and once again, was received very well by all the folks in the Lions Club and up in the Blue Lake Springs area and Arnold. I attended the Calaveras Chamber Mixer at the Mind Matters in Murphy's for their celebration. I believe they've been in business here for close to 10 years and doing a fantastic job. Very honored to be part of that operation and that celebration. So one of the few organizations that really shows that it works very well in Calaveras County. On Friday, the 21st, I attended a 2-hour meeting with Supervisor Garamendi with Assemblyman Frank Bigelow and 2 supervisors from Amador County, talking on a variety of issues, one being wild and scenic, another being, of course, what we're faced with as jointly as both Amador and Calaveras County are looking at things, and with representation from Assemblyman Bigelow. And as always, Frank is just one heck of a guy. He's the kind of guy that'll sit down and talk turkey with you, if you will, and tell it the way it is. I was very honored to be at that meeting. Very honored relationship that we have with both Assemblyman Bigelow, Assemblyman Berrien, and also Congressman Tom McClintock. Those things are very, very important when you have a situation happening in our county, that we have the ear of our national representatives and our state representatives. And those folks have always picked up the phone and always answered the call. I was going to attend the fly-in day, but unfortunately we got a new dog, a new rescue dog, so I had to acclimate the dog to me and my wife, and I think I lost. But anyway, she's a great dog, Nikki. Other than that, we have some dates on calendar. We've got some things planned for the board. We got to solidify some dates. We're moving forward on things. I understand we'll be looking at interviews for our building official here coming up very shortly. We've got some other issues that are coming up, but I'm very excited about the fact that we can sit down and talk about the marijuana issues that we're facing and getting input from the public. Very important. I am also scheduling, as part of my education, I scheduled this afternoon after hearing Lieutenant Hewitt, I will be taking a helicopter ride and taking a look at those grows that are in my district and in the other districts. Once again, it's my goal to get every bit of information I can, and seeing things from a neutral eye before I make that decision. Although I will maintain my position originally, that you got to convince me. I'm not from Ohio, but you got to show me where it's going to work. And the only thing I'm really, really concerned about is which way we go, is how we're going to finance the protection of this county and the public safety. And that means everybody in this county. Every 44,000 people in this county, plus our transient occupant people that come in as far as their vacations and things of that sort. So, having said that, that's my conclusion. Any staff comments? Madam Clerk?
I do. I'd like to announce the Government Center Frog Jump is going to be held on Tuesday, May 9th. The board will have it on their agenda and will recess from 11:30 to 1:30 for the frog jump activities. The information has gone out to departments to get some frog jockeys going, and usually the custom is that anybody who's new jumps a frog. So I'm anticipating that we will have at least 5 people on this dais who will be jumping frogs that day. It's a $10 registration fee, and you can decide if you would like your registration fee to go to the Humane Society or to Friends of Calaveras Animal Services. If you need a form, please let me know and I will provide you with one. But it's a great day, and last year we had a record number of 57 entries, so we'd like to top that this year if possible.
Thank you, Madam.
And the kissing frog is optional?
Not in your case.
Madam Clerk, is it, Madam Clerk, is it bring your own frog, if you will choose?
You can actually bring your own frog, or you will be provided with a frog that day. So it's a great event, lots of employee interaction, lots of employees bring their kids and their family members, and there's lunch provided.
Okay.
I had
County
nothing.
Council?
No, I'm good, thank you.
CEO Lutz?
No.
Okay. Ladies and gentlemen, thank you. It's been a kind of a long day. Thank you for coming, and we'll see you folks next meeting. Oh, I'm sorry, public comment. Wait a minute. Sorry. We're back in session. We have to continue public comments, folks.
I'm sure I'm the last one.
I'm sorry. Thank you
That's
very
okay.
much for your
Thank you for-
patience.
Thank you for your patience. May I begin? Good afternoon, County Council and staff. My name is Jackie McGowan, and I'm a consultant in the cannabis industry. I am not from Calaveras, as most of you know. I'm here because I assisted some businesses with their registrations, and I am now emotionally invested in seeing some of them make it. Not all of them, though. Some of the ones I assisted deserve to be shut down. They were only interested in exploiting your county, raping your land, and making as much money as they possibly could here. If you move forward with your ban ordinance, as it is written currently, it is operators just like these that are hoping that you implement a ban. Because if you do, they can continue to operate with the limited immunity protections under Prop 215. Let us not forget that Proposition 64 reduced this crime to a misdemeanor. It's also extremely important to remember that the provision in SB 420 affording legal protection to patient collectives and cooperatives will not sunset until 1 year after the Bureau posts a notice on its website that licenses have commenced being issued. After that date, all cannabis collectives will have to be licensed. You can try and ban collectives all you want. You will not be able to challenge Prop 215 until the collective model sunsets. The earliest that can occur is January 1st of 2019. Due to my profession, I track local regulations closer than almost anyone in the state, and I actually specialize in bans. I decided to really dig into the actual steps that were being taken in implementing some of these restrictive ordinances. So last night I looked at Placer County, Siskiyou County, and Butte County in detail. But the most interesting that I'd like to speak of right here, right now, is what's happening in the state's largest county, that's LA. So Los Angeles County on April 17th this year just introduced something called the Enforcement of County Ban Against Medical Marijuana Dispensaries. This was submitted by the Sheriff's Department, the District Attorney's Office, and County Council. And they called this their game plan. In anticipation of this plan, the county supervisors have been discussing just how to pay for this. The Board of Supervisors has located $25 million to fund this game plan and will be voting on that allocation in the coming weeks. I have several other examples that I could share with you, however, my 3-minute limit restricts me from doing so, but I can tell you this. All of these counties followed the exact same strategy. Step 1, they detailed the game plan. Step 2, they located funding. Step 3, they implemented enforcement. Any intelligent person should be able to deduce that a ban without a plan is doomed to fail. Mr. Oliveira, I was here the night that you were the sole dissenting vote against the urgency ordinance. Your lone reason for voting it down was because you wanted a guarantee that the sheriff's office would have funding within 2 weeks. You were protecting your brothers in law enforcement, and I don't blame you. They need you to protect them now, and you're not. You are an arm's length away from a funding source for enforcement. Measure C passed by 2/3 of the majority here. You have an opportunity to both give your constituents what they want and the sheriff what he needs. This is no longer a marijuana issue. This is a public safety issue. The only way out is through sensible regulations. Thank you.
Thank you. Any other public speakers for public comment? Seeing none, thank you very much for coming, folks. Oops, we have one more. This, yeah, have you
No,
already
I
talked?
didn't do public comments.
I
Not this
don't
morning.
know, she didn't. She did
No,
on
I
an
didn't.
agenda item. Go ahead.
No, I did it during an agenda item.
Agenda on the helicopter.
Right. I have a question. Is there a frog size requirement for the frog jump?
I didn't understand that. What was it?
At the fair, it has to be 3 inches, so I just wondered.
It's an event that is brought here from the fairgrounds, so whether they have those kinds of restrictions, I don't know.
Okay, well, you might not want to bring a tree frog. Okay, having said that, I read through the proposed ban ordinance, and there are a few things that caught my attention, and number one is it did not eliminate cannabis dispensaries. So I would have liked to have seen those eliminated, but if they're going to be left in the ban ordinance, then we need to address those in relationship to 17.91, specifically K on 17.91. And K, that needs to be mandatory, not an option. In other words, dispensaries shouldn't be allowed to grow just anywhere they want in the county and as much as they want. They shouldn't be allowed to grow anywhere other than at their facility. Okay, the other thing I noticed is that we need to give law enforcement and code compliance the authority to enforce the ordinances without a warrant. That's not addressed in here. Also, I don't see anything that really addresses odors. So we need to have something in here that addresses odors, saying that it can't impact the neighbors. That's been a real problem with many, many people. Another issue I didn't see in here is water transportation. And my neighborhood's a good example. We have a lot of large water trucks hauling in water. I would ask that that be included in this ordinance as a nuisance. And I found the ordinance is somewhat vague and ambiguous, and I would like to know if it's possible to have this reviewed, once you have all the input, to have it reviewed by an outside counsel that specializes in land use. So, thank you.
Thank you. Any other member would like to speak on public speaking? With that, meeting is over, and thank you for coming. Keep working it.